Well, gentlemen, thank you again for coming down for our interviews. This is a rare situation where we had you both in here earlier this year for a primary, and now we have you back again for the general. You'd think it happened more often. You'd think we'd be more accurate, but whatever. We got this one right. So, all that having been said, I assume you've both been provided not only with the waiver, but also the letter kind of outlining how we're going to handle the endorsement process and announcing it, things of that nature?
Yes.
Yes? Jim? Yes? Okay. So I don't have to get into that. Since you've already been through this process before, you're forcing us to ask totally different questions because we don't want to hear the same answers you gave us last time. So the first question that we'll be asking in this race is this, and we'll start with Jim because we're starting with whomever's on my left, historically. Jim, when a person is elected to or appointed to the district court bench, there are numerous different, they're informed about the existence of numerous different diversionary programs, such as DUI court or the drug court or the veterans court. Based upon your knowledge of those specialty court programs right now, what areas would you like to, if given the opportunity, focus some of your time and efforts and energies to improve? Or alternatively, what specialty courts would you like to see further developed while you are on the bench? And obviously, Joe, you'll have an opportunity to answer that as well.
Actually, I'm interested in all three. I have a little bit of background on the what's called the DUI court or the drug court, because a good friend of mine, Jack Lehman, is the one who brought him to Nevada. He didn't pioneer the concept nationally. He learned about it on a judicial trip to Florida, where I guess they did start it there. And it became a real passion of his because, as he explained it to me, he was able to intervene at a critical time in someone's life. And if someone made the commitment and followed through on it, they had a chance to change the course of their life. So that's pretty big. Because I do think that at the heart of most criminal activity is either drug abuse or alcohol abuse or mental illness. And I think until we learn to address those, we're going to just repeat the same things over and over again. The Veterans Court program, which I've learned a little bit about from talking to Mark Stevens, who's a justice of the peace in Henderson. He's super knowledgeable about it, of course, because of his background. But I think it's an amazing program to acknowledge, while it's not always acknowledged by the Veterans Administration, but that mental health is most definitely a real issue for many of our veterans who returned from overseas, from multiple generations. And my dad was a veteran, and although it wasn't ever diagnosed, he definitely had PTSD. He served on Iwo Jima as a Marine. So I think that these diversionary programs are excellent, and I would like to participate in them in whatever way a judge in the capacity I would have if I'm elected, which is to be a 90% civil, 10% criminal overflow. Because right now, Judge Bell and others handle those other programs.
And Joe, before you get a chance to answer, Jim brings up a good point. Just for the edification of the panel, right now, District Court 24 is splits half of their time toward civil, half toward criminal. That may or may not remain the case, irrespective of who gets elected, since it is done on a seniority basis. However, so it may go to a completely civil department, which is to what Jim is referring. And again, but when we say civil, we're talking about breach of contract issues, slip and fall cases. We are not talking about family law issues. We'll be getting to the family law bench or custody type matters. We'll be getting to that later on this afternoon. Okay. So I just wanted to clarify that for anyone who might be listening in, or watching, I should say, or people on the dais. With that interruption, specialty courts. Joe, what would you like to see expanded or improved upon?
I am a big fan as well of the specialty courts. I think they do an excellent job at focusing on issues that before they were created, I think were for a large part glossed over, if you will. As Mr. Crockett said, a lot of the issues that these people are facing, with drugs, veterans, there's underlying issues that may contribute to what they've done that causes them to come into court. So I think the specialty focusing on with a judge who's knowledgeable, who's dealt with all those types of issues already and has that experience is a very good thing for the community at large as well, not only just the individuals who are there, but for us as a community. So I think they're very good, and you know, not to say ditto to what Jim said, but you know, I'd love to participate to the extent asked, whatever capacity they want to do it.
Okay. Well, Joe, neither one of you gentlemen, since both of you are running for an open seat, neither one of you have had the pleasure of an RJ evaluation as of yet, although in all probability you may have participated in them in giving your insights toward seated judges. So what did you think? No, not going to ask that. The question is this: what ideas do you have to make the RJ's biennial judging the judges perhaps either more transparent or just more accurate or more digestible for the civilians who are reading it and really relying upon the figures that those reports contain?
That's a great question. I think the poll is overall a very good thing because, you know, the public at large, you know, luckily is not dealing with judges, so they generally don't know who judges are, what judges do. So I think the poll serves a good purpose. As your question implied, though, I think it can be better because, you know, it's an anonymous poll, you know, and attorneys are supposed to limit their evaluations to judges they've appeared in front of in the last year. That's one of the instructions you get on there, but there's nothing in place that guarantees that attorneys do that. When we go online, you can select any judge you want to, even if you've never been in front of them, even if you last were in front of them 5 years ago. So to make the poll better, I think accountability would definitely be a good thing. How you do that is probably a tougher question. I think it'd probably take a lot of work by the RJ to, you know, theoretically they could do searches of attorneys and make sure they appeared in front of that judge, but that would take a lot of work by the RJ staff that I don't know is practical. Right now it's relying on the honor system, which hopefully attorneys are honorable, but those are my thoughts.
Okay. Jim, any improvements on the RJ poll?
Yes, I think the concept is great, but even though I realize the poll is conducted by the RJ, not by any government entity, I would like to see a collaborative effort between the RJ and the RJC, the courthouse administration, where we lawyers could have our bar cards scanned at a courtroom that we were in to document, much like security guards have, to document that they were at a place when they say they were or as they were required to be. Because I do have serious concerns about which attorneys really do go to the courthouse, because it's really a very small percentage of attorneys who actually do go to court. And I wonder how accurate these numbers are in terms of the lawyers who are casting ballots for judges. They could artificially inflate or negatively impact a judge if some lawyers wanted to, single shot somebody or do something like that to try to sway the appearance of a judge's credentials. There are judges that I've appeared in front of on repeated occasions, and yet I've seen their evaluation poll results, and I think, boy, that doesn't really jive with my personal experience with them. I wonder how that can be. But then again, I talked to lawyers I talked to a lawyer the other day who was complaining about a decision that a judge made in his case, and he was telling me about how that impacted his opinion of her. And so I was familiar with the issue he was talking about, having to do with LLCs and trying to pierce the veil. And I said, well, you know, that's why LLCs were created, was to make it extremely difficult to pierce the veil. And I said, from what you're telling me, and he looked at me and he said, you know what, you're right. I was just so angry that I didn't get things happening the way I wanted them to happen. But he said, you're right. We knew going in that it was going to be extremely difficult, and I misplaced the blame for the decision on her being either biased or not smart enough to figure it out, when in fact, that law worked exactly the way it was supposed to the disadvantage of my client. So we do, in fact, have retaliatory votes being cast, and perhaps some votes that are not retaliatory but artificially supported. And I think that if the judges felt they were being evaluated by the lawyers appearing in front of them, I wouldn't mind it if there was a little device in the court when you came in, you scanned your card to document the fact that you were there. I really wouldn't. And I think that the public is at such a disadvantage about knowing information about judges and who to vote for that anything that is a useful, documented, reliable tool would be welcome.
Well, Jim, and I'll give you a chance to follow up with this, Joe. How accurate of an assessment do you think the RJ poll results are in general? Well, with respect to the retention or overall performance ratings, I mean, how accurate are they, based upon your personal experiences?
Yes, I would say for the most part, I tend to agree with probably 80% of the determinations. But I know nothing about the justice court judges, and I know nothing about the muni court judges, so because I don't practice there. And so even though I know some of the judges who are on those benches, I don't cast ballots for them to help them out because I don't practice there. I don't know how they're doing their courtrooms. But by and large, I would say that the judicial evaluation poll results that I see, I tend to agree with 80% of the time, maybe 75% of the time. But to have 20 to 25% outliers, that's very significant, because out of 32 departments, that's 7 or 8 departments. That's a lot. So the questions are kind of broad, you know. Does the judge appear to avoid the appearance of impropriety? Does the judge appear to have any bias regarding gender, and so forth? Those are all very important questions. But the strongly agree or strongly disagree in the way they grade it, I don't know that that really gets you where you need to be.
And Joe, generally speaking, how do you feel, how accurate do you feel that the ratings are?
Generally, I feel they're fairly accurate. You know, again, like I said earlier, they do rely obviously on attorneys. And you know, we have to hope that they're filling them out honestly, fairly. And yeah, I've had similar experiences where you go in and it's okay, am I grading according to how I was ruled on, and was how I ruled on, is that what's upsetting me, or was I, you know, was the ruling correct with in accordance with the law? But generally speaking, my experience has been that they are pretty accurate in terms of the results you get. You know, I'd actually like to see the results disseminated even wider than they are. Again, how that happens is another.
I'm sorry, what do you mean by disseminated?
You know, publicized, I guess, so more people know about them.
Okay.
I have a question. The people you sent to jail, or respectively sent to jail, a good portion of them are mentally ill, and you say drugs, etc. But is there anything that you take into consideration when a person is mentally ill and commits a violent crime? Or do you just, for both of you, do you just send them there to either withdraw from their drug abuse or
No, go ahead.
or what is there for them to, they cannot be unmentally ill, but what is there for them to help
And
knowing that they're already mentally ill.
and it's Joe's turn to answer that one first, and then we'll go to Jim.
Well, to begin with, neither of us are judges right
Yeah,
now,
I know.
so we haven't done that before. But there are in place right now various programs. Now, I am not that familiar with those because I do exclusively civil law. Do not deal with the criminal aspect of it, which is what you're referring to. But there are programs, probationary type of programs that the individuals can be placed in, to help them instead of going to prison. It's like, okay, we want to rehabilitate, and I think anything that can help rehabilitate, any member of our society really is a good thing.
The mental health issue comes in place in two ways. First, and I don't do criminal law anymore. I did during the first 4 or 5 years of my practice, but that was about 35 years ago. But two ways mental health impacts criminal law. First, there's an inquiry made as to whether or not the person should even be held criminally responsible. Because if they are mentally ill and don't even know the difference between right and wrong, well, you can't punish them into a state of mental health, okay? Punishing them or confining them is not going to make them mentally healthy again. Instead, they need to be treated. So if a person fits in the category of somebody who is mentally ill and therefore not capable of forming what they call criminal intent, those people don't actually go through a trial. Or if they do go through a trial, the jury is asked to make a determination. Do you think this person was mentally ill at the time so that they weren't able to form the intent to commit a crime? Regardless of how horrendous the act was, the question is, did we have a fully functioning human being in there? And then secondarily, we have had, although they are diminishing all the time, we have had facilities for the criminally insane. People call them criminally insane to distinguish the fact that they are a danger to themselves or others. So it's really an oxymoron because it's not criminally insane, it's just mentally ill. And that could run the gamut in terms of how it appears. But I think that until we really focus on the mental health issue, mental health scares us. And so when we see somebody who does something that's horrendous and we don't know what to do with them, we want to punish them, or we want to confine them, or maybe in some instances, they want to put that person to death because they're so horrified by what they did. That, of course, does not address the real problem. There was a case that I won't take up your time with, but Khalil Ben Natala, many years ago, a mentally ill man who murdered somebody horrifically. And he was able to bypass the criminal system. He wasn't put in prison. He was sent to Lakes Crossing up in northern Nevada for a long period of time. And they got him on medications that got him squared around to the point where he could function and work, and they monitored his behavior. The bad thing that happened was they lost track of him. And when he quit coming in for his treatment and medications, he killed again. He killed 2 people horrifically, 12 years after his original murder. So it's something that we as a society need to really invest in. And we will save so much money on the other side by dealing with it appropriately, I think.
Evidently, Mike does not have any questions, which is surprising.
It's very close to the hour.
Yeah, I think Mike's waiting until we're at 28 minutes elapsed before he asks his question. One issue that we've been discussing with a lot of candidates this weekend, well, today I should say, has been the avoidance of the much vaunted appearance of impropriety when it comes to individuals who have significantly donated to a particular judge's campaign, and when an old law partner or your best friend who you went to college with, who happens to be a lawyer too, appears in front of you. If elected for both of you gentlemen, what safeguards are you going to have in place to avoid those situations as best as possible so that you don't find yourself in an undesirable situation? What's up with Jim?
There is, on the Secretary of State's website, you can go there and find out everybody who contributed to any judicial candidate's campaign and the dollar amount and the name of their organization. That's one place to start, but I would put the onus on myself as a district court judge. I would have the list with me so that if I had any questions in mind, I could say, that name sounds familiar. I could look it up and say, well, they donated a check for $250 to my campaign, and I would disclose that. However, there will be instances where you're going to have people on both sides who may have donated to your campaign. One of the interesting things that develops is you can, in an effort to make sure you don't favor somebody, if you don't remove yourself from the case, you can try so hard to show that I can be fair, even though John Paris is involved in this case. And I will bend over backwards to make sure that I don't favor John. And I bend over backwards so far that I end up not giving John a fair trial, and I end up actually being biased kind of against him, drawing conclusions in a light least favorable to him, just to make sure that I don't make the error of favoring him. So I do John a favor by saying, John, I know you gave $2,000 to my campaign. Not true, I'm just using that fictionally.
You gave 20,000.
No, because that would be a violation of current election law. So that has not happened.
But
He's off to the Bahamas now.
but I think that you have to err on the side of removing yourself if you feel even the slightest little twinge. The problem happens when, if a judge gets so overly zealous about making sure that maybe it's somebody who ran against him, okay? And so he wants to make sure that he doesn't decide cases involving that person or that person's law firm or supporters or something. But pretty soon, you've got a judge just getting rid of all the possible cases there are, because everything could be tainted with some kind of a risk. So I've seen judges who have been asked to recuse themselves from cases, which is what they do when it's not a formal challenge for cause. They recuse themselves from the case. And the judges have said, you know, I don't think I have an issue here. I don't think I'm going to be biased or prejudiced towards one side versus the other, so no, I'm not going to voluntarily recuse myself. Then the lawyer has to conduct a hearing and have another judge hear the case. Now what happens? Now is that judge so offended by the fact that the lawyer wasn't respected by the judge recusing himself? Now has the lawyer created a bias and prejudice where there wasn't one before? I think that all that a judge can do is be, in fact, honest and have integrity. And you just have to trust that that's going to be the case, that the judge really will have that kind of integrity. If you don't think the judge will have that kind of integrity, then that judge is really not fit to be a judge.
And Joe, before you get a chance to answer, we had used my name somewhat mockingly, as if I would have anyone $2,000. But just to make things real clear, I haven't donated money. I haven't donated a dime to either of these gentlemen, nor have I actually quite candidly done it to any of the judicial candidates this season. But in discussing things with Mike Viswani, our president, we agreed it would be inappropriate if I were openly supporting someone from a financial aspect and then ostensibly sat as a neutral arbiter of who is the better or best person for a race. So,
I should have used a completely fictional name.
Honestly, it gave me an opportunity it gave me an opportunity to disclose that, which is something that, quite honestly, I hadn't done up until today, up until this exact interview. So, for those poor people who are watching all 8 hours of this in their spare time, they'll now know that fact. So, Joe, appearance of impropriety.
Repeat the question for me.
Yes. How would you avoid the appearance of impropriety with respect to people who have financially contributed to your campaign, or people who may have been, closely associated with you professionally or personally over the years?
Sure. So I think the first thing there is full disclosure, open, honest, complete, and full disclosure. You know, I have been in the position as an attorney before, where we're appearing in front of a judge, only to find out as the case moves along that, oh, this, you know, there's this fact that we weren't aware of in terms of, you know, campaign contribution or, you know, like your hypothetical example, former roommate or that type of thing. You know, that's disappointing to learn when you're already into the case. So full, open, complete disclosure up front, I think, is the first key. Now, having said that, I have also, you know, there's a judge who did do that. I remember who, this was years ago, but this particular judge informed us, you know, at the first hearing we had in front of her that she had been partners with one of the attorneys in the case, and you know, that gives the attorneys at the very least the opportunity to evaluate that, you know, take that into consideration and think, you know, is that something that we need to be concerned with or not? Having said that, you know, as a judge, you're subject to ethical canons, and those are basically what you need to live by. But I think up front, full disclosure is definitely the key.